So hello dear students, welcome to Bajirao Ias Academy interview guidance program. So in this lecture we are going to discuss about the independence of the election commission. Recently a series of petitions were filed in Supreme Court to decide the appointment of the chief election commissioner. Since Election Commission of India is responsible for conducting free and fair elections in India, independence of the election commission is very important in order to conduct free and fair elections and further strengthen democracy, and also make sure that Election Commission of India is not working as per the whims and fancies of the political class at that time. So therefore, in this context, recently Supreme Court has passed a verdict on the independence of the Election Commission of India. Now this verdict has been in conformity with providing more independence to the Election Commission of India in providing free and fair elections. So in this context, there is a chance that in your interview UPSC may ask about the Election Commission of India and recent verdict of the Supreme Court on Election Commission of India, and at the same time the recently passed Election Commission of India Service Conditions, Tenure and Appointment Act 2023. So in this context we will be understanding about both the verdict as well as the recent legislation passed by the center on the Election Commission of India, right? Now firstly we need to talk about the Election Commission of India, right? So a 5-judge constitution bench, whenever more than 5 judges presiding over a particular case, that particular bench is called as the Constitution Bench of the Supreme Court. So the 5-judge Constitution Bench of the Supreme Court anonymously ruled that the appointment of election commissioner and election commissioners shall be made by the President on the advice of a committee which consists of Prime Minister, Chief Justice of India as well as Leader of Opposition in the Lok Sabha. Right, so I hope you understand. So what is the verdict? So the verdict is the appointment of the chief election commissioner shall be made by a committee consisting of, or recommendation of a chief election commissioner shall be made by a committee, and that committee consisting of Prime Minister of India, Leader of Opposition in the Lok Sabha as well as the Chief Justice of India. Now the committee consisting of all these members will recommend a name to the President, and ultimately President will appoint one person who is recommended by this committee as the Chief Election Commissioner of India. However, if you look at the previous appointment of the Chief Election Commissioner, there is no such committee. Just Prime Minister recommends one name from the bureaucrats to the President for the appointment of Chief Election Commissioner. Since Election Commission of India is a constitutional body, the appointment of the Chief Election Commissioner must be done in such a manner that it should be transparent and accountable, and Election Commission of India's independence and constitutionality must be protected. It should not be worked as per the whims and fancies of the political class at that time. So in case there is no leader of opposition, for example in the current Lok Sabha there is no opposition leader, so there is a set of criteria to recognize a leader of opposition or the opposition party. A party which gets 10% of the total seats in the Lok Sabha will get the status of the largest opposition party in the Lok Sabha. Since no party gets 10% of seats, the leader of the opposition post is still vacant. So in this context, if there is no leader of opposition available, then the leader of the largest opposition party in Lok Sabha in terms of numerical strength will be part of such committee, right? So if criteria is not met, if there is no leader of opposition or leader of the largest opposition party in the Lok Sabha, then the numerical strength will be considered. The largest party in terms of the numerical strength will provide the leader of opposition, or will be considered as leader of opposition for the selection of Chief Election Commissioner in this committee. Okay, so I hope you understood so what the Supreme Court judgment. Now if we go in detail about the Supreme Court verdict, the Supreme Court stated that the reading of the debate of the Constituent Assembly, right? So the responsibility to frame the Constitution is given to the Constituent Assembly. Everyone knows about that. Now, in the Constituent Assembly, there were various debates and discussions with respect to the independence of the Election Commission of India. So Supreme Court says, taking clue from the debates of the Constituent Assembly on the appointment of the Election Commission of India, so Supreme Court says that these debates in the Constituent Assembly makes it clear that members of the Constituent Assembly were very clear that the elections must be conducted by an independent commission, and an independent commission in which the commission members should be appointed through a fair procedure and an independent functioning of those commission. So in this context, Supreme Court has taken inspiration or clue from the debates of the Constituent Assembly. So however, while ordinarily court cannot encroach on a purely legislative power, so this is considered as a purely legislative power because the Constitution has given the power to frame the rules with respect to the Election Commission of India to the Parliament. So whenever Supreme Court has been making such rules for the functioning of Election Commission of India, then it has been considered as encroachment upon the legislative power of the Parliament. So, but in the context of the Constitution and inertia on the part of the legislature, and this convention and this trend has been further continued by the executive, and there is a certain degree of inertia on the part of the legislature. So because of such inertia, there's a vacuum which is being created, and it makes it necessary for the court to intervene, right? So since there is existence of a vacuum with respect to the appointment of the Chief Election Commissioner, so it makes the court to intervene in the legislative functioning of the Parliament. So apart from that, on the question of whether the process of removal should be same as the Chief Election Commissioner and election commissioners, okay, so there's a process of appointment and also the process of removal for the Chief Election Commissioner as well as the election commissioners. So with respect to the removal, Chief Election Commissioner enjoys more powers, right? So he cannot be removed from his post ordinarily, but he should be removed from his post similar to the judge of the Supreme Court. Okay, so with this context, Supreme Court says that Supreme Court stated it cannot be same as Chief Election Commissioner. The removal of the Chief Election Commissioners and election commissioners is not same. Okay, so because Article 324 is applicable only for the Chief Election Commissioner and not for the election commissioners, and this is what the Supreme Court has stated with respect to the removal of the Chief Election Commissioner and election commissioners. Now after that, when it comes to the funding to the election commission, so earlier for the funding, election commission is completely dependent on the government of the day. Okay, now if you look at the expenditure charged upon and expenditure charged from, so expenditure which is charged upon is not subjected to voting. So however, when we talk about expenditure which is charged from is subjected to voting. So in this context, Supreme Court has left the question of funding to the election commission and establishment of a permanent secretariat in order to provide more independence and need for more expenditure to be charged on the consolidated fund of India, and it should be decided by the government. Okay, so therefore this question of funding to the election commission and establishing a secretariat, so everything will be left to the government to decide over a period of time. So this is broadly what the Supreme Court has said with respect to the Election Commission of India. Now after that, we need to talk about certain challenges in the implementation of the same verdict. Now what are those challenges? So the first and foremost challenge is Constitution places power to make any law on the appointment of Election Commission of India in the hands of the Parliament. Okay, so any law which deals with the appointment of the Election Commission of India or chief election commissioners, election commissioners, so it should be in the hands of the Parliament. Supreme Court cannot intervene and it cannot make laws. So otherwise it is considered as violation of the separation of powers. So that has been provided by the Indian Constitution. So therefore, in this context, Supreme Court ruling has posed questions with respect to separation of powers. However, Supreme Court has stated that the ruling will be subjected to any law made by the Parliament. So what does this mean? When Supreme Court says this particular ruling is subjected to any law which is made by the Parliament, in a subsequent period of time, if Parliament makes any law with respect to the appointment of the election commissioner, then the law which is made by the Parliament stands effective, right? So or it stands active, or it has more weight compared to the ruling of the Supreme Court. So this is subjected to any law which is made by the Parliament. So this means that Parliament can bring a law to undo this judgment of the Supreme Court. Okay, so there's another view is that since there is no law made by the Parliament on this issue, the court must step in to fill the constitutional vacuum. So earlier we have already discussed that there is a constitutional vacuum because of the inertia that is being shown by the legislature. Since there is a legislature, the Supreme Court has intervened and Supreme Court has made a law on this. Okay, Supreme Court has made a law on this. Now, if you look at the Vishaka guidelines, 1997, in those guidelines also Supreme Court has given certain directives and certain guidelines to prevent the sexual harassment of women at the workplace. So taking inspiration from such act, the Parliament of India in the year 2013 has passed one such legislation to prevent the sexual harassment of women at workplace. Now in this context, we need to understand what is the view of the government in this context. So the government simply says that the provisions with respect to the appointment of the Chief Election Commissioner and election commissioners will be decided by the Parliament. So therefore, the Supreme Court must exercise the judicial restraint. So this is what the opinion of the centre with respect to this particular verdict. Now we have to understand the constitutional provisions with respect to the appointment of the Election Commissioner of India. Okay, so Chief Election Commissioner of India or Election Commission of India, the constitutional provisions which are being related to this. So the first and foremost constitutional provision which is mentioned in part 15 of the Indian Constitution, Article 324 to 329. Okay, so Article 324 to 329 deals with the constitutional provisions with respect to the appointment of the Election Commission. So it deals with the elections establishes a commission for these matters. Right, so in order to conduct elections, an independent constitutional body will be created, and Article 324 to 329 deals with this particular Election Commission of India. Now if you look at the structure of the Election Commission of India, so originally Election Commission of India used to have one election commissioner, right? So but there was a legislation which is being passed, right? So Election Commissioner Amendment Act 1989. So after this particular act, a multi-member Election Commission of India has been created. Now as per this act, one Chief Election Commissioner and two election commissioners were being provided to assist the Chief Election Commissioner in his functions. So according to Article 324 of the Indian Constitution, Article 324 of the Indian Constitution, Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners which may be decided by the President. Okay, so time to time President may decide the other election commissioners. So this is what Article 324 of the Indian Constitution says. Now if you look at the appointment procedure of the Chief Election Commissioner and election commissioners, so Article 324 subclause 2 provided for the same. the appointment of the chief election commissioner and other election commissioners, they shall be appointed by the president. Okay, so CEC and EC must be appointed by the president, but it must be subjected to the provisions of any law made on behalf by the parliament. Okay, so president have the powers to appoint the members, however it is subjected to the law which is made by the parliament, and this is how the appointment procedure usually have. Okay, so in the appointment of the chief election commissioner, so there's a huge role of the executive. So that is where the independence of the Election Commission of India is being compromised. So earlier procedure used to have a law minister who suggests a pool of suitable candidates to the prime minister. So a law minister suggests a name from the pool of suitable candidates, and then from the suitable candidates one name will be recommended to the president by the prime minister for the appointment as chief election commissioner. Right, so you can see there's a huge role for the executive when it comes to the appointment of the chief election commissioner. So, and that is where the independence of the Election Commission of India is being compromised. And in order to conduct free and fair elections and in order to strengthen democracy in India, we need to have an independent election commission. So it should not work at the mercy of the political executive. So therefore this is how the procedure used to be earlier before the judgment of the Supreme Court. And apart from that, the president determines the conditions of service and tenure of the office of election. Okay, so president after appointment of the chief election commissioner, he will decide the conditions of service and tenure of office of the election commissioners. Now when it comes to the removal of election commissioner of India, right, so they can resign anytime or they can also be removed before the expiry of their term. Okay, so either they are being they are being removed or they can resign anytime during their service. The chief election commissioner, we all know how he is being removed. The chief election commissioner is being removed similar to the judge of the Supreme Court. Okay, so that is being one of the most complex procedure to remove the chief election commissioner. Okay, so it generally involves passing resolutions, signing of resolutions in the both houses of the Lok Sabha, and then holding an inquiry, and after that allowing both houses to pass that particular resolution with the special majority. Everything, this is a very complex to remove the chief election commissioner. It is very complex. So therefore, the chief election commissioner cannot be removed except on the recommendations of the chief election commissioner. So this is with respect to election commissioners. There are 2 election commissioners, and those 2 election commissioners cannot be removed except on the recommendations of the chief election commissioners. So however, election commissioners can be removed, not like they can be removed, but the procedure for the removal is not similar to the chief election commissioner. Okay, so this is the removal procedure, and this is the actual verdict of the Supreme Court in order to bring in more independence in the functioning of the Election Commission of India. So however, since Supreme Court has said that the verdict of the Supreme Court for having a committee which consists of Prime Minister, Leader of Opposition in the Lok Sabha, and Chief Justice of India should select a name and then recommend the name to the president for the appointment as a chief election commissioner. However, that particular ruling is subjected to any law which is being made by the parliament. So taking inspiration from that particular verdict, now the parliament has come in and it has brought a new legislation. Okay, so the legislation is Chief Election Commissioner and Other Election Commissioners Appointment, Conditions of Service, Term of Office Bill 2023. And this bill also has a lot of it has created a lot of controversy in recent past. Okay, so this is also in news. So why it is in news, we will discuss later. Now, apart from this, we need to understand the key provisions of the bill. So what are the key provisions of the bill? So this bill replaces the election commission. So there was an earlier legislation with respect to the election commission. So this particular legislation has replaced election commission conditions of service and transaction of business act 1991. So this particular bill addresses the appointment, salary, removal of the chief election commissioners as well as election commissioners. Okay, so this legislation particularly deals with appointment, salary, removal of chief election commissioners and election commissioners, and this is what the key provision of the bill. And what is the appointment procedure which has been prescribed in this legislation? So the appointment procedure involves the chief election commissioners and the election commissioners will be appointed by the president. Okay, so similar to the earlier appointment procedure, and this is what the Supreme Court has recommended. So however, the basic difference between Supreme Court verdict and the legislation is the selection committee. And this selection committee is having a lot of influence of the executive. How? Because this selection committee will consist of Prime Minister and Law Minister and then Leader of Opposition in the Lok Sabha. Right? So now Supreme Court has said that CJI should also be part of the committee, selection committee, for recommending name to the president for the appointment of chief election commissioner. So however, this particular legislation says that only Leader of Opposition in the Lok Sabha, Law Minister and Prime Minister will recommend name for the appointment of the chief election commissioner. Okay, so this has been significantly deviated from the earlier Supreme Court mentioned selection committee. Okay, so however, the bone of contention in this particular issue is, so if there is no leader of opposition in the committee, so if there is no leader of opposition in the committee, even if there is absence of law minister, the recommendations of the selection committee is still valid. Okay, so they are still considered as valid. So this is where the actual conflict has started with this particular legislation. So changes in salary and conditions. So what are the changes in salary and conditions? Earlier, the chief election commissioner and election commissioners used to receive salary similar to the judge of the Supreme Court. So however, now they have been made at par with the cabinet secretary. The salary and service conditions of the chief election commissioner and election commissioners will be equivalent to that of a cabinet secretary. So under 1991 Act, so it was equivalent to the salary of a Supreme Court judge. So this is also another issue which has been creating a lot of controversy with respect to the new legislation. And when we talk about the removal procedure of the election commissioner, chief election commissioners as well as the election commissioner, so the bill retains the constitutional provision article 324 clause 5 that actually allows the removal of the chief election commissioners is similar to the removal of the judge of the Supreme Court. However, when we talk about the removal of the election commissioners, so they cannot be removed except on the recommendation of the chief election commissioner. Okay, so the removal procedure is same which is being mentioned in article 324 clause A clause 5 of the Indian Constitution. So ultimately this legislation having a lot of executive influence and even virtually reducing the role of leader of opposition in the Lok Sabha, in the selection committee, and reducing the salaries of the election commissioners and chief election commissioners, bringing at par with the cabinet secretary, are some issues which have to be considered by the executive and the parliament. Now, independent election commission is very important for a functional democracy like ours. So those independent election commission will ensure free and fair elections. So the elections which are not influenced, the elections which are not biased towards any political party. And the Election Commission of India is not working in the interest of the ruling party, providing a level playing field for every candidate and every political party. This is what we need to talk about. So that is where the need of an independent election commission actually actually requires. So in this context, the Supreme Court judgment has provided for the better functioning, better independence of the Election Commission. And with this legislation, we can see some deviation of the roles and responsibilities in terms of office, security, safety, independence of the Election Commission. So apart from that, an independent secretariat has to be provided. And this legislation is largely silent on financing of the Election Commission. So it has to be it has to have independence. It should have independence with respect to funding, financing of elections, everything, right? So apart from that, there's also a need for reforms in the electoral process, or electoral reforms, in order to prevent the criminalization of politics and also increase the participation of women in politics, and at the same time make sure that every citizen participates in the political process, in voting, right? So further strengthening the Election Commission of India are very important. Okay, so this is all for today's session. Thank you. So please subscribe to our YouTube channel and also hit the bell icon. Thank you.